Good morning. Today's date is July 26, 2022, and we are glad to be sitting in Lorain County in Elyria here for arguments today. The panelist, Judge Carr, on my right, Judge Sutton on my left. I'm Judge Teodosio, so I'll be presiding, keeping track of time. We have two oral arguments set for today, the first one being State of Ohio versus Lavell Gibson, case number 22CA011847. Each of you will have 15 minutes to present your argument. The appellant may reserve up to 5 minutes for rebuttal. As I said, I'll be keeping track of time, so just let me know how much time you would like to reserve. If you would like to reserve time, and I'll probably interrupt you to let you know as you get close to that rebuttal time. We don't use names of victims or children in the arguments. Please refer to them other than my name. And other than that, I can assure you that Judge Carr, Judge Sutton, and I have read the briefs, and we are prepared to proceed if you are. Would you like to reserve some time?
Judge, if I may, I'd like to reserve 3 minutes.
3 minutes. All right. As I said, I'll let you know as you get close to that time.
Thank you.
All right. Thank you.
May it please the court, my name is Rick Braley. I'm appearing today on behalf of the appellant of the state of Ohio and Lorain County Prosecutor J.D. Tomlinson. And I'm here to ask that this court reverse the trial court's order suppressing the evidence from an OVI traffic stop. And there are two alternative reasons for this court to reverse that order, both of which are independently sufficient for reversal. The first is that the trial court incorrectly determined that the defendant was arrested at some point during his short transport from the scene of the traffic stop to the Elyria police station. The evidence in the record indicates that he was only arrested after being transported after failing his field sobriety test and refusing a breath test. At that point, there was ample probable cause for his arrest, and the trial court should not have suppressed any evidence. The second alternative reason is, even if this court were to agree with the trial court's determination about the timing of the defendant's arrest, the trial court still erred by suppressing the evidence because there was probable cause before the time that the defendant was placed in the backseat of the cruiser to determine that there was a suspected OVI offense and that he could be transported. So before we move into those legal arguments, I want to outline some key facts for this court to consider as we go through this. This is a traffic stop that occurred late February 2021, 9 p.m. in the evening. It occurred at the intersection of Lorain Boulevard and Midway Boulevard. There are multiple businesses around that area. It's a very busy intersection according to the record. There was a report of a reckless driver. Officer Catalinato was the only officer who responded to that dispatch. She saw the defendant's car matched the description of the report. The car was pulled past the stop bar. It was obstructing traffic.
But she did not see any reckless driving per se, did she? She just saw the car in the middle of the intersection at the light while he was waiting, I'm assuming, to clear the intersection.
That's correct. She did not directly observe any reckless driving, just the report.
Counsel, before you proceed to, obviously we'll have a transcript of the proceedings and so forth, but I was a little confused because you can be an inch or two over the stop bar and still be, or you can be a few feet even, and still not be out in the intersection per se. Can you give me a little more detail as to what the record reflects where the car actually was?
I wish there was more description of how far over the stop bar it was. All that the record reflects from the testimony is past the stop bar and it was obstructing traffic. The officer immediately approaches the vehicle, notices that the defendant has very bloodshot eyes, he has glassy eyes, he has very slurred speech. And she noticed there's an alcohol beverage odor coming from inside of the car. The defendant is asked whether he has been drinking that evening. He gives an inconsistent response. At first he says, no, I have not been drinking. Then he changes that to, I had had 2 drinks. So based on those observations, the officer determined that field sobriety testing would be appropriate. And at that point, she asked the defendant whether he would consent to field sobriety testing, and he had agreed to the field sobriety testing. There were really 3 options that she had. She could perform this field sobriety test right at the intersection there, and she excluded that because of how busy it was and it'd be dangerous. The second option was the nearby parking lots. And she determined that it was unsafe to perform the field sobriety testing there. One, because the conditions there would not be suitable for him to successfully perform the tests. They would harm the administration of the tests themselves. And the second is a concern about officer safety. She would have to be doing that by herself alone in the evening without an officer present with her. And the third option was to drive less than 5 minutes away to the Elyria Police Station. And she decided, based on her observation at that point, the defendant's agreement to do the field sobriety testing, that that was the most appropriate action to take. At the suppression hearing, only Officer Catalanato testified. The defendant did not offer any contrary testimony about conditions in the parking lots. There was no testimony about whether there would be an appropriate location for the test to be performed there. The trial court, though, still decided to suppress evidence. And I think that was wrong for two reasons. So we'll go into the first one, which is the trial court determined that at some point during the short transport, an arrest must have occurred. And when we look at the Barker factors for an arrest, the most important one is an intent by the officer to arrest the defendant. And the evidence does not show that that intent existed. Officer Catalanato explicitly testified, I did not arrest him. I did not tell him he was under arrest until after we went to the police station and he failed his field sobriety and he refused his drug test.
But you seem to be arguing that it's a subjective feeling of the police officer. That's not what the case law says, right? The case law says that would a reasonable person feel that they were under arrest.
Yes, and I believe that since he agreed that there was field sobriety testing that he was going to perform, that the circumstances supported by the investigative detention. And I direct this court to the First District's opinion in City of Cincinnati versus Blair, which really provides some instructive guidance for how to consider this, marking lines between the detention and arrest. There was a crash by Interstate 71. There was a chaotic scene there. It would be unsafe for the officers to perform field sobriety testing at the scene of the crash. They put the defendant there in the backseat of their cruiser, and they drive that person to the closest place they can find to perform the field sobriety testing. Many of the facts are similar here. This is a longer drive than this involved in Blair. But the testimony in this case indicates that the closest place that Officer Catalanato thought she could do it safely was the police station. And
Something that bothered me when I was reading, I was trying to figure this out. So the defendant was stopped at a red light. Okay, and he was over the stop bar, past the stop bar, and the officer testified he was obstructing traffic, and there was no more evidence than that. Okay, so I've got the facts right so far.
Correct, yes.
And then the officer just stops him and proceeds to investigate while he's still obstructing traffic.
Judge, I am not sure if when exactly she ordered the defendant out of the vehicle. There is not a good quick timeline in the record about the minute by minute kind of breakdown of this. Unfortunately, there is no video of the incident as well based on Elyria Police video policy at the time. So that's, I wish I could give you more facts about it, but it's not in the record.
The only reason I'm wondering is because I'm thinking, when you're following somebody that you think has some indicia of being drunk and, impaired and not able to drive sufficiently, you might see, some a traffic violation, and you don't just pull up behind them and say, stop right here in the middle of the road. You allow them to pull over, and you give them the sufficient area to pull over before, you would charge them with not pulling over, or whatever, not obeying. So I just don't understand why he wasn't allowed to proceed through the intersection when the light turned green and pull over.
I cannot answer that question, Judge. There was no testimony.
Bothered me when I was reading that. I don't understand. Okay.
I wish that would be in there too as well, Judge. But I think for our purposes, it's not a significant detail that would indicate that there was an arrest until he got to the station.
Can you remind me, counsel, of when the decision to tow the car happened?
The decision to tow the car was when the decision had been made that they were going to the police station for the field sobriety testing. And the reason in the record that was made is that they attempted to find another person to come and move the car for the defendant, but there was no one available. And secondly, they did not believe that based on what they had observed of the defendant at that point, the glassy eyes, all the other circumstances mentioned, that he was not capable himself of driving it away from the spot that they found the car.
Okay, so they actually towed the car right from the middle of the intersection, not, as Judge Carr sort of indicated, having the car pulled off to the side of the road?
That is my understanding from the record, is that basically the police saw this car stop there, that's where the car stayed. It wasn't as though there was some sort of pulling to the side of the road or anything like that. So, and going back to this Blair decision, I think that a review of that case shows the flaws in the trial court's analysis here. And most notably is a key factual finding for why the trial court decided to suppress evidence was its determination that the officer could have done these tests in the nearby parking lots because, quote unquote, it was not necessarily unsafe there. It's very important that there's absolutely no evidence in the record to indicate that there's any support for that finding. In fact, Officer Catalano testified directly against that. She said it was unsafe. Not only because of the conditions that might affect the administration, but because it also might affect her officer safety.
And that's what I didn't quite understand either, because officers do that all the time.
I'm sorry, can you?
Well, she was concerned about doing the field sobriety test because of officer safety. I mean, she could call for backup, or officers do that all the time by themselves. So I'm trying to figure out why that was such a concern.
There was a backup officer on the scene who stayed with the car until it was towed.
Right, but I'm saying there could have been additional officers. Was it such a high crime area, for instance, or something like that, that she would feel uncomfortable doing it in a get-go parking lot?
She testified that she did feel uncomfortable. She was a female officer with a larger defendant who was with her. She did not have the ability apparently to call for another backup officer because one was already on the scene. And since it was less than 5 minutes away and he was agreeing to field sobriety testing, she believed it was more appropriate.
Should that be something we consider?
I think that his agreement to the field sobriety testing.
No, I'm sorry, let me stop. Should it be something we should consider, that she was a female officer and he was a big guy?
I think that there is a concern for her safety based on that consideration. That there is a particularized safety concern for her in that particular situation.
And counsel, just to get a couple more facts correct in my head. So the officer, if I understand correctly, the defendant actually agreed to take the field sobriety test, correct?
Correct, yes.
Okay. And then was handcuffed, right, and put in the back of the cruiser. Is that correct?
Yes.
Okay, and then transported to the station for this test.
Yes, Judge, that's correct.
And was there testimony on the part of the officer? Did the officer testify that he would have been free to leave during that time?
She indicated that he was not free to leave because he was under investigative detention. And it's mostly because the observations that they had already of an ODI impairment situation.
Thank you.
Counsel, while we have a little pause here, you're at 3 minutes and 16 seconds, total time left, so.
Okay. I will reserve that. Just wanted to remind the court that I do have that second reason. We might talk about that once I come up again.
All right, very good. You'll have 3 minutes and 16 seconds then for your rebuttal. Thank you, and we'll hear from the lead. You have 15 minutes.
Good morning, Your Honor. Attorney John Kopasakis from Jim Ellis, Wilson, Maryland, Fritz. I'm here on behalf of Mr. Lavell Gibson and Attorney Doug Merrill. Your Honor, we believe that the trial court appropriately suppressed this matter. We believe that the requisite elements for an arrest were met. We believe also that the officer did not have sufficient probable cause to arrest. Primarily at issue is whether or not the officer had the intent to arrest Mr. Gibson. We believe that based on the evidence that was displayed, based on the testimony, that she did have the requisite intent, even if she said that she didn't. We also believe that the officer's testimony goes towards her credibility to the trial court. Your Honor, we believe that she showed that intent when she informed Mr. Gibson that she was going to be towing his car. She locked up Mr. Gibson in the back seat of her car. She had him in handcuffs. And then when the officer was questioned, the officer stated that there was no chance that Mr. Gibson was returning to the car that night because she didn't believe that he was adequate to drive home, despite not actually having sufficient probable cause to arrest him at that point in time. We would make the distinction here between this matter and Blair because in Blair, the officer moved the defendant to the other side of the street, to the other side of the highway. Mr. Gibson was transported to the police station, and it was a significant drive to the police station, passing up multiple locations where the officer could have performed the field sobriety tests. Whereas in Blair, it was a couple of feet. The location that they were at was significantly dangerous in Blair. There was, in the court's findings, they found that there was traffic coming and going that posed a risk to everybody on the road at the time. We don't believe that such a risk exists here. In the back and forth between counsel and the officer, there was a conversation in regards to whether or not the officer could go to the brand new, well-lit, highly camera get-go that was right next door, that was right there. The officer said that it did not meet her standards to perform the test.
As to the consent to the field sobriety test, was he aware that he was going to be transported to the police station when he consented? In other words, was he told that before he consented, or was he anticipating doing them at the scene there?
From our read of the record, it looks like he was anticipating to do it there. Unfortunately, the record isn't clear on whether or not he was anticipating to be transported to the police station at that time.
And how does that factor into our decision, his consent to the field sobriety?
I'm sorry, my hearing is atrocious.
Oh, how does that factor into our decision, his consent to the test?
His consent to the test is the same as any other individual's consent to the test. They believe they would be passing the test and they could do it there. We believe that would be a factor against finding probable cause, as many officers find a refusal to perform the field sobriety test as a factor to believe that the individual will be intoxicated. Further, we believe that his consent has nothing in regards to due to his, at the point of giving consent, his understanding that he'd be arrested. When the officer then tells him, you need to find someone to pick up your car because you're not coming back to your car that night, at that point, it's an understanding that he will be arrested. He has then met that element that he understands he is being arrested. And we believe that the officer has met that element of translating to him that she intends to arrest him. You're not coming back to your car this evening, find someone to go pick it up, otherwise we're going to have it towed. And then proceeding to handcuff him, put him in the backseat of the car, and transport him to another location.
Counsel, let me ask you a question too. It seems like there's a trend here, so it probably is not in the record, but what was in the record in regard to the complaint about reckless driving?
There was a report from dispatch that there was a black car that was recklessly driving. From what we can tell, the officer did not witness any reckless driving. When questioned, the officer indicated that why she stopped Mr. Gibson's automobile is because it met the description of that report, and that he was past the stop car. So it almost seems like it was a pretextual stop.
But what I'm asking you is just about the actual report of reckless driving. Was there anything other than dispatch? Did dispatch indicate, or is there anything in the record that indicate, was that a citizen informant? How did that come about?
It doesn't appear to be any information. It just appears in the record that it's a black car that was driving recklessly.
Okay, but usually when that happens, it's somebody has reported another driver or something.
Yeah, we didn't see anything in the record in regards to who was reporting it, why they saw it, why they reported it, why they believed it.
Or what activity was constituted reckless.
There doesn't appear anything in the record, Your Honor.
Okay, well, that gets me to my question in regard to, does this all matter if there was probable cause to arrest him at the scene?
I believe that there was not sufficient probable cause to arrest him because there was no indicia of reckless driving.
You don't need to have somebody recklessly drive in order to arrest them for driving under the influence.
We don't believe that there was sufficient information there at the time of the arrest for the officer to believe, for a reasonable person to believe that Mr. Gibson was intoxicated or impaired. It may bring you to the point where you want to perform further investigations, but not necessarily to arrest him for.
So I make sure I understand. The court found, and you don't have any problem with these findings, the court found that he was past the stop bar and obstructing traffic in the intersection.
Yes, we believe that yeah.
Okay. Now, we don't have a lot of information about that in the record, but that's a significant finding, isn't it? That could be reckless in and of itself.
Only in the sense that it gives a reason for the stop, but if you go through the record, there is a back and forth in regards to where the car was stopped past the stop bar, and the officer indicated that it was turning left and the light was changing. So it appears that Mr. Gibson was there, basically stopped, waiting for traffic to clear so he can safely turn. And that's when the officer stopped.
But it was a red light.
It looks like the record stated that it was changing light. So it was green going to red.
Thank you.
And is any of this other information contested with evidence in the record that the officer observed slurred speech? Was that contested?
That doesn't appear to be a...
Glassy eyes, was that contested?
That was
An odor of alcoholic beverage?
That wasn't contested, Your Honor.
Okay, and an admission of having 2 drinks after saying that he had not had any drinks?
That fact wasn't contested.
All of that was, okay,
Correct.
thank you.
Even to that, though, we believe that there was not sufficient probable cause to arrest. Ohio courts have found that you can drink and drive, you just cannot be impaired and drive. You can smell of alcohol and drive, and you just cannot be impaired and drive. We believe that there was sufficient information there to believe that Mr. Gibson had drank alcohol at the time of arrest, but there was not sufficient evidence to believe that Mr. Gibson was impaired. And the finding that he was not impaired means that he did not commit a crime.
Just quickly, you know, Holman had pretty similar facts. Eyes were red and glassy, and odor of alcohol, admission to consuming beverages, and if I remember Holman correctly, they said based on those facts, the totality of those circumstances, and the trooper.
And you have
said in Mr. Holman.
You have to forgive me, but I believe there might have been, and I just don't have Holman committed to memory, there was other factors.
Was there erratic driving in that case, maybe?
I'm sorry.
Was there erratic driving in Holman?
I believe so.
Not present here?
I believe so, and I think that was the grounds for the initial stop with Holman.
Okay.
There was no witness to erratic driving. There's an anonymous, at least what appears to be an anonymous report of the situation.
All right, so Holman would be distinguished by the fact there was no erratic driving here observed.
Yes, Your Honor.
All right.
How much time do I have left?
You have about 5 minutes and 20 seconds left.
I think I've made my arguments. Thank you, Your Honor.
Let me see if there's any other questions here, or anything.
Thank you,
All
Your
right,
Honor.
thank you very much. So, Counsel, you have 3 minutes and 16 seconds.
All right. Thank you, Judge. And, you know, I'll keep this brief, and it's going to be just springing off of some of the questions we just heard. And that's really the probable cause that existed at the scene to arrest the defendant. And I think the circumstances there were very clear that there was impaired driving, not just drinking and driving. It wasn't just slurred speech, it's very slurred speech. Glassy, bloodshot eyes, odor of alcohol beverage, admission to drinking after saying I had not been drinking. And also, although there was not observed erratic driving, that's correct, there was a report of it that was made to the police and they were aware of that. And, you know, I appreciate the Holman, comparison which I believe is apt, and I think that that is absolutely controlling of this court on that matter. I'd also bring up to this court's one of their recent decisions in Snowburger, and there it says impaired ability to drive shown through odor of alcohol, bloodshot eyes, and slurred speech. So even if we decided that the reckless driving is reports immaterial, those 3 factors are there right in this case as well. In the defendant's brief, they cite our district's decision in High from 2017. And there this court said that there wasn't probable cause when there was just an unspecified odor of alcohol paired strictly with an admission to having a few beers. This has very different circumstances, much more indicative of an OVI. So in sum, this court should reverse the trial court's order And there are two possible reasons, but even if, the court decides to go along with the trial court's determination of when the arrest occurred, there was still sufficient probable cause at the scene. And if there are no further questions, I'll conclude.
Thank you.
All right, thank you both for your arguments here today. The court will take the matter under advisement, issue a decision in due course, and the clerk of courts will mail each of you a copy the day the decision is released. The opinions are also posted, as you probably know, on the Supreme Court of Ohio's website. But a very interesting case. Thanks for being here today and arguing.
Thank you, Judge.
Have a good day.